Students, in this lecture number 9 on the Indian Contract Act 1872, I am going to discuss with you very important type of contract which is called standard form of contract. In standard form of contract, one party lay down all the terms and conditions in a paper and present that contract to the other party for his acceptance, but the other party to whom that contract is given is not in the equal position to negotiate about the terms and conditions of the contract. He has got only two options, either to accept the contract or forget about the contract. So, standard form of contract in ordinary meaning means take it or leave it type of contract. In this type of contract, the one party is not in a position to negotiate the terms and conditions laid down in the contract. That party just have two got options in this type of contract, either to enter into the contract or forget about the contract. Why this standard form of contract is used? It is used as a mode of convenience, because when a large number of contract have got to be entered into by a person, then for the sake of convenience, a standard form for various contract may be used. Some of the most important examples of standard form of contract are an insurance company contract, a railway ticket, signing up for your email, social networking sites are some examples of standardized contract. In this type of contract, the one party is in the weaker position because there is unequal bargaining power of two parties. And in view of this unequal bargaining power of the parties, our courts and legislature have evolved certain rules so that interest of the weaker party can be protected under the law. And these rules are, first rule is of reasonable notice. This rule lays down that in standard form of contract, reasonable notice must be given by one party to the other party about the terms and conditions of the contract. If no such reasonable notice is given by one party to the other party, then the contract will not be enforceable in the court of law. This principle has been given in the case of Henderson versus Stevenson from the House of Lords. Let us study what is written in the notes. A reasonable notice must be given by the person delivering the document to give adequate information about the terms and conditions laid down in the contract. Where an adequate notice is not given, then the promisee or acceptor is not bound by the terms and conditions of the contract. This principle was propounded in the case of Henderson versus Stevenson from the House of Lords. What were the facts of this case? In this case, a person buy a ship ticket. On the face of it, only boarding place and arriving place was written. But on its backside, there were certain terms and conditions which the person did not see. Nor anything was written on the face of the ticket to turn over and look at the back of the ticket. Simple reason given by the court in this case was that a person cannot agree to a term. I repeat, a person cannot agree to a term if he had not seen or is not told about it. So, reasonable notice to the terms and conditions should be given before or at the time of contract when it is to be signed. How it can be done? It can be done by printing on a ticket 4 conditions see back, or by obtaining signatures on the document containing the terms, or otherwise by explaining the terms to the other party to the contract. So reasonable notice can be given in such a way. And the second important rule which is laid down by the courts and legislature is that the document which is proposed to be a contract must have the characteristics of contractual document, because document can be divided into two categories. One category is called contractual document and other type of document is called only a receipt. If the document contain all the terms and conditions of the contract, then that document will be the contractual document. And if the document is the contractual document, it will be binding. But if the contract do not contain the terms and condition, then it will not be the contractual document. Hence, it will not be enforceable in the court of law. So what is written in the notes? In standard form of contract, there must be a contractual document. If the document is not a contractual document, then it cannot be enforceable in the court of law, because the document in the standard form may be contractual document or a receipt. Okay, if a document clearly explain the express and implied terms in the document, then the document is the contractual document. But if the document do not explain the express and implied terms in the document, then it is a receipt. And most important point in this case, that it must be signed by the person accepting the terms and condition mentioned in the document. The contract must be signed by the person accepting the terms and condition mentioned in the document. And there should not be the presence of any misrepresentation, fraud, mischief, and other elements which makes a contract void. Okay, so any type of misrepresentation, fraud, mischief, and other elements which makes a contract void should not be present in the contract in order to make an agreement enforceable by law. The third important way to protect the weaker society in standard form of contract is that the terms of the contract should not be unreasonable or unfair. If the terms are unreasonable, if the terms are unfair, then it will not be binding on the weaker party. If the terms of the contract are unreasonable, if the terms of the contract are opposed to the public policy, then they cannot be enforceable in the court of law. What is the meaning of unreasonable terms of the contract? Unreasonable terms of the contract can be said about those terms in the contract which contradict the very purpose of the contract. For what purpose the contract was made? If the condition and terms of the contract are contradictory to the very purpose of the contract, or if the terms are against the public policy, then it will said to be the unreasonable terms. In a very important case of Lily White versus Manuswamy, this principle had been clearly explained. In this case, the laundry receipt contained a condition that in case of loss or destruction of your cloth, only 15% money of the market price of the cloth will be returned. That means to say, if your cloth is of the value of rupees 10,000, only 1500 will be given to you as a compensation. This clause was held unreasonable by the court and was held being against the public interest. Hence, this term will not be binding to the other party. If the cloth will be lost, then the laundry has to give 100% of the money to the person who was the owner of that clothes. Okay. And if there is any type of exemption clause, what is the meaning of exemption clause? Exemption clause is that clause by which a person want to escape from a liability by making the exemption clause, that he will not be liable for these things. If such type of exemption clause is given in the terms of the contract by which the very purpose of the contract is breached, then that exemption clause will not be allowed. So no exemption clause is allowed to permit the non-compliance of the basic contractual obligation. Basic contractual obligation means that obligation which is fundamental, which is necessary for the contract. Does a dry cleaner has to be answerable even if the contract contains all sorts of exemption clauses if the cloth is altogether lost? That means to say, dry cleaner has to pay the compensation fully. And most important point is the fifth point. In case there is any exemption clause in the standard form of contract and there is some confusion regarding the interpretation of that exemption clause, then first of all the strict construction shall be applied to the exemption clause. And if there is any ambiguity, if there is any type of problem in the interpretation of that exemption clause, that has to be resolved in favor of the weaker party. So this is something about standard form of contract. What is the standard form of contract and what are the various ways to protect the interest of the weaker party? Thank you very much.